How does the Constitution define citizenship? Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Herewith. Citizenship, by birthright in any case, has once again become a presidential campaign issue. In 2018, then-President Donald J. Trump proposed to end birthright citizenship by executive order. 4 weeks ago, he proposed the same for his re-election campaign. Naturally, this has people looking at the Supreme Court case law on the subject of citizenship. Tellingly, these people, most of whom are not lawyers, don't understand how confused that case law really is. Various obiter dicta, or by-the-way sayings, in at least 2 key cases only add to the confusion. The case of presidential eligibility is more complex still, several generations removed from the Constitutional Convention of 1787. So Americans, at their next opportunity, must reform the Constitution to clarify questions of citizenship and presidential eligibility. I'm going to hold a brief class on birthright citizenship, then tell you how a famous Swiss citizen and contemporary of the framers tackled the problem, and how I would write a constitutional amendment to address these issues. But first, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, especially this t-shirt that I have chosen for today, which depicts troopers in silhouette against an American flag, and this caption, "Freedom isn't free," and it isn't. And here is how we preserve it. One more thing, if you like what you're about to hear, you can like this video. You can also subscribe to my channel if you're using a desktop or a laptop or the Rumble app on a mobile device. So, let's get ready to rumble. By long and so far unchallenged tradition, the common law recognizes 2 ways to establish birthright citizenship. The first we call jus soli, or the law of the soil, also known as jus loci, the law of the place. According to that, a person is a birthright citizen of the country on the soil of which he is born. Second is jus sanguinis, or the law of the blood. According to that, a person inherits the citizenship of his parent or parents. Jus soli is an English common law philosophy, whereas jus sanguinis derives from Roman law. Roman citizens were very particular about who was a citizen and who wasn't. Thus far, the Constitution has never had specified citizenship by jus sanguinis. Courts have generally recognized jus sanguinis in the case of a person born to 2 citizen parents. When only one parent is a citizen, that weakens the jus sanguinis claim. For that reason, many countries attach continuous residency requirements to the citizen parent to validate a jus sanguinis claim. The jus soli claim excites the greatest controversy today. Does it or does it not apply to a child born to a non-permanent resident? His Majesty's Kingdom in fact says no, and I have a link in the description to a tweet saying just that. Nevertheless, we have the 14th Amendment, which reads in relevant part, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." Judge Andrew P. Napolitano firmly believes that settles it. A jus soli claim is absolute. But in fact, the case of U.S. v. Wong Kim Ark, 169 U.S. 649, 1898, doesn't quite hold that. I have a link to it in the description so you can see for yourself what it does hold. Quote, "Citizenship as prescribed in the 14th Amendment extends to U.S.-born children of foreign subjects or citizens who, at the time of the child's birth, are permanent residents and are carrying on business in the United States." Close quote. Jus soli also assigns citizenship to place of birth if otherwise the child would be stateless. A convention to reduce statelessness does exist and has existed since 1961. That convention provides birthright citizenship places of last resort. Furthermore, common law does not seem to have kept up with advances in transportation. What are the limits of the territory of a country? International law recognizes ocean waters bordering a country's coast for a fixed distance as the territorial waters of that country. Likewise, the air above the lands or waters of a country constitutes its territorial airspace. To complicate matters further, transportation over long distances is no longer as hazardous as it once was. During the Roman Empire and at the formation of English common law, no woman would dream of traveling by ship while pregnant, and air travel would not become imaginable until two bicycle repairmen built and tested a heavier-than-air powered craft at Kitty Hawk, North Carolina in 1903. In fact, the Convention on the Reduction of Statelessness provides that the country under whose flag any ship sails or any aircraft flies is the birthright citizenship country of last resort for any children born aboard such ship or aircraft while said ship or aircraft is in international waters or airspace. That is, unless the child can inherit the citizenship of his or her parents. Logically, therefore, a child born in the territorial waters or airspace of any country rates the same consideration such a child would have if born on land. The question then is, does a woman giving birth aboard a ship or aircraft qualify as doing business in the country of registry or the country owning the waters or airspace involved? Well, if she's a ticketed passenger, maybe, but not if she's a stowaway. But that's a debate for another time. Presidential eligibility is another matter altogether, or should be. During the Constitutional Convention, John Jay, co-author of The Federalist, first Chief Justice of the United States, recognized at once that a child born in one country to citizens of another had a choice of birthright citizenship to claim. Such a child had dual loyalty. John Jay specifically wanted presidents of the United States to owe no loyalty to any country except the United States. Before I tell you where John Jay found his answer, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many countries struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, either way, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy to your future. So, where did John Jay find his answer? He found it in a work called Les Droits des Gens, or The Law of Nations by Herewith de Vattel, published in 1758. I have a link in the description to a place where you can read Book 1, Chapter 19, the relevant chapter. There, Section 212 clearly defines a natural-born citizen as born in the country of parents who are citizens. Furthermore, in other sections in that chapter, Vattel settles all the other just soli questions arising from transportation or offshore birth. So, a person born in territorial waters is born in country, and a person born in international waters is born in the country whose flag the ship aboard which he was born flies. But jus sanguinis clearly takes precedence in Vattel's treatment. It's only logical because jus sanguinis is a much older tradition. Also, a child born to a person on any military or diplomatic station, Vattel deems born in country. So Congress properly deems Senator John McCain of Arizona a natural-born citizen because he was born on an American naval base in the Panama Canal Zone. The Wong Kim Ark case does hold that children of foreign diplomats do not rate American birthright citizenship. 3 presidents of the United States have been recognized as elected who were not natural-born citizens by Vattel's definition. Thomas Jefferson was the first. Why not George Washington or John Adams? Because in the formation of the United States, all relevant authorities deemed persons born in what became the territory of the United States to persons who were British colonial subjects at the time to be natural-born citizens. Now, slavery, it's an unfortunate chapter that Vattel did not even treat. I take the position that the intended and actual effect of the 14th Amendment was to recognize former slaves as citizens. So, the proposition that the first natural-born citizens were persons born in America after July 4th, 1776 is false. The Constitutional Convention, under John Jay's urging, clearly meant to recognize all persons born in America to American colonists as natural-born citizens. But Thomas Jefferson was born in France to 2 American colonials. Not wishing to leave him out, Article 2, Section 1, Clause 5 says that a citizen of the United States at the time of the adoption of this Constitution would still be eligible to the office of president. Chester A. Arthur, John Garfield's running mate, skated on this requirement because his parents were not both citizens. He became president with the assassination of Garfield. Under the 12th Amendment, which says no one who can't run for president can run for vice president either, no presidential elector candidate should ever have pledged to vote for him. They did, because the Constitution provides no enforcement mechanism for presidential eligibility, and because people probably had forgotten what a natural-born citizen is. The third person who skated on presidential eligibility? Barack Obama, of course. His father was a British colonial subject. Now, in February 2005, then Representative Nathan Deal of Georgia introduced his Citizenship Reform Act to redefine birthright citizenship. It would have declared a child a citizen only if the mother was a citizen or lawful permanent resident. Now, if the child was born in lawful wedlock, the father could also be the qualifying citizen parent. Sadly, that act did not pass. In the spirit of Donald Trump's proposal and Vattel's Law of Nations, I offer this new constitutional amendment. Section 1. With respect to presidential and vice presidential eligibility, the phrase natural-born citizen shall refer to one born in country or on any diplomatic or military station of the United States, provided that both said person's parents shall be citizens of the United States at the time of the birth of the subject person. Section 2. No state shall appoint any presidential elector subject to any pledge to vote for a candidate for president or vice president who shall not meet this and all other requirements for presidential eligibility. Neither shall the Congress appoint or allow to be appointed any presidential elector for the District of Columbia subject to such a pledge to vote for such ineligible person. Neither shall any vote for a constitutionally ineligible candidate be considered valid. Section 3. The Congress of the United States shall have the duty and authority to enjoin the certification of any constitutionally ineligible candidate for president or vice president as qualified. Furthermore, if a candidate can establish reasonable grounds to suspect fraudulent or other criminal interference with the appointment of presidential electors, the Congress shall have the duty to investigate any such allegations. The Supreme Court of the United States shall likewise have appellate jurisdiction in any controversy arising out of the election of a constitutionally ineligible president or vice president by reason of dereliction by the Congress of any duty specified above. Section 4. With respect to citizenship in the United States by reason of birth. Clause 1. No person born in country or on any diplomatic or military station of the United States shall be considered a citizen by birth unless at least one parent shall be a citizen or permanent resident of the United States at the time of the subject person's birth. If the subject person is born out of wedlock, then he or she shall be considered as a citizen by birth only if the mother is a citizen or permanent resident of the United States at that time. Clause 2. No person born in a place other than the above places shall be considered as a citizen by birth unless both parents shall be citizens at the time of the subject person's birth. Section 5. The phrase born in country, as used in this article or any law made pursuant thereto, shall refer to persons born in the territory of the United States or in the territorial waters or airspace of the United States or aboard any ship or aircraft registered in the United States or belonging to any of its armed services, so long as said ship or aircraft is in international waters or airspace at the time of the birth of such person. Now, I'd say that handles all the questions Vattel treated, even to the application of citizenship to persons born at sea. Now, the treatment of persons born in the air follows logically from Vattel's treatment of persons born at sea. And remember, when Vattel said at sea, he meant in international waters. It would also authorize, indeed direct, the Congress to enforce presidential eligibility requirements. Furthermore, it would direct the Congress to investigate allegations of the kind of fraud alleged in the election of 2020. Now, it might take another 1800-style constitutional crisis to induce Congress to propose and the states to ratify such an amendment. But already, some are asking openly why men like former Governor Arnold Schwarzenegger of California or entrepreneur Elon Musk are not eligible to the office of president. I say we ought to settle this question once and for all, and with my proposed constitutional amendment, we can. Links in the description to the article, to the tweet describing new just soli restrictions in the UK and elsewhere in Europe, to the Wong Kim Ark case, to where you can read the relevant chapter in Vattel's Law of Nations, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to oursilverlines.com, as I also mentioned. You know already about how to like a video and share this video and subscribe to this channel. And don't hesitate to leave a comment. Tell me what you think. Should we restrict citizenship? Is it time to settle for next time the question of jurisdiction over another election of 2000 or election of 2020 before it happens? Now, if you'd like a debate on what the benefits of citizenship ought to be, leave a comment to that effect and I will consider it for another video. This is Terry A. Herewith delivering another declaration of truth and reminding you to let the truth set you free. And be sure to look for and follow me on Twitter. That way, at a minimum, you'll never miss a thing.